for the respondent number I'm for the respondent number 126, my lord. It's for speaking to the minutes.
Because I'm for respondent number 7 in this matter.
Yes.
I appear for respondent number 18 RP in the matter.
Yes.
I'm for respondent number 13.
Yes. So Redopara appears for the petitioner, my lord.
Yes, he was online 2 minutes back.
My lords, in whichever case this matter is already taken up by the alternate bench, my lords, who have the sitting right now. Justice Suman Shamit, my lord, peruses the last order.
Or remove from the board. We'll remove it from the board.
Yes.
Yes.
Only sees the last order, it will be very clear.
Remove from the board. Liberty to move.
May I please, your lordship? I was muted. Now only I say, my lord, yes. I have my video is to be. I cannot, my lord. I cannot mute myself. The video. Somebody has to unmute me. Somebody has to unmute me.
Hello.
I cannot unmute myself. The host has to unmute my video. Yes, the video, I cannot unmute it. Yes. The audio is unmuted. The video is not unmuted. But my lord, somebody has to, the court officer has to unmute my video. All right. No issue. Yeah. But the all issue is, if I'm entitled to a protection of the MSMLE Act and the notification, in all limits they submit, my lord, I must get it. If I am not entitled to the benefit of the notification, it should be frankly denied. And the only forum which can decide the issue is either the civil court or this court. The reason is because, my lord, in the NCLT, the ICICI Bank is not even a party at all. And I filed an application for bringing him on the party arrangement. I pleaded that the doctrine of reconventionalism.
Mr. Nirupara, it passed an interim order. Why can't you go to the regular court?
No, all issues, your Lordship's order, all that I said is, I do not your Lordship's order. Let me not be interrupted. If the court is not implied, you not pass an order. Let me submit. Let me submit. I wanted to say. Because I appear because I take up this issue because I consider my client has got a case.
Yes.
And otherwise, but if this, otherwise the matters are rejected once, twice. And the bar for so many years, give it up. Otherwise, the client is not going to proceed. I consider, I believe personally that this is a cause where a entitled to justice has been denied, and certainly calls are capable of and have a duty in all humility, a duty to do justice.
Yes.
And my lord, I take your lordship because there is a judgment which has come from the Madras High Court. The bench of the Madras High Court, I read 2 paragraphs. I believe my client is there physically there, or my junior is there physically. Mr. Chavan is there. Mr. Chavan is there. Can you hand over the judgment of the Madras High Court? The judgment of the Madras High Court.
It's for speaking to the minutes.
No.
Referring to judgment.
Let him make his submission. Yes, we call upon you if there's something. Yes.
No, my lord, my all attempt is to convince your lordship. And if I am not able to convince your lordship, I will reject my plea. I have no grievance at all. Page 10, my lord, the Madras High Court judgment, page 10. Para 10. May I read, my lord, para 10.
You are speaking to the minutes, basically.
Para 10. Or the Madras High Court, judgment of the Madras High Court. Lordship for my lord, para 10.
It should be a copy of the petition.
Yes. Para 10.
Is which page, but?
Page number, page number is, there's a bottom of the page, right? Paragraph, which is paragraph, pagination, I cannot find about paragraph 10.
Yes.
Paragraph 10, yes. The primary contention raised by the petitioner is that The petitioner being an MSME unit is entitled to the framework for revival and rehabilitation of micro, small and medium enterprises as per the MSME Act of 2006. But the convention of the respondent is that when Section 13 notice was issued, the petitioner did not bring it to the knowledge of that the petitioner is an MSME and entitled to the benefit of the notification dated 29/5/2015. The convention of the bank cannot be accepted since at the time of processing the loan documents itself, it would have declared the unit comes under the MSME. It is pertinent to state when the MSME certificate is issued to the unit from the central government in the bank in the column bank name, it is mentioned Canara Bank. Further, in this digital era, when there is a interlinking of data, such an argument from the bank cannot be entertained. In fact, the petitioners have produced additional types set with wherein the sanction letters were produced. In the sanction letter, it has been specifically stated in serial number 7 under column classification, priority SME enterprise manufacturing. Under serial number 15, it is stating SME 3 normal risk grade 4, etc. Therefore, the convention of the bank is absolutely false. Here, I'm an MSME is not in dispute, and when the 13th notice was issued, and much before also, I raised my claim as an MSME. Then, paragraph 12.
Yes.
And again, paragraph 11 also, the brief paragraph. In paragraph 11 also, I may put it. When, in fact, when a specific question was raised by the bench, whether the Canara Bank has formed any committee which is mandated under clause 2 or the framework for revival and rehabilitation of micro, small and medium enterprise dated in 2015, it was submitted that no such committee was formed. No bank or financial institution, including ICICI Bank, not a single committee. Nobody ever. Yes, now.
All these you can raise before we clarify all these you can raise before the regular court. It's an ad interim order we have passed.
No, I read two paragraphs.
This
2 minutes more. 2 minutes more. I will go by what your note says, but let me read it. That means I'm reading 2-3 more sentences only, not much. Not much. Paragraph 11, I'm skipping that. Then the relevant portion of the clause is extracted here. I'm not reading that. At the next page, the above clause specifically states bank shall constitute one or more committees, but the bank failed to constitute such committee. Then paragraph 12 and 13, only it will take 2-3 minutes only. Further, in the above clause 2, subclause 2, it is specifically stated that stress micro, small and medium enterprise shall have access to the committee. When no such committee was formed, then the stress MSME like the petitioner were deprived of any such opportunity to approach the committee. The bank is contending that the petitioner has not raised the issue of benefit of the MSME scheme at the earliest point of time. Well, there is no committee, then such a plea of the bank cannot be entertained. On this ground itself, the petitioners are entitled to relief. On this ground itself, the petitioners are entitled to relief. Then para 30. The bank have raised the plea that the present litigation is hit by the principles of reciprocity. At the same time, it had also stated that the petitioner for the first time have raised the plea for the benefit under 2015 notification. This court is also considered that when the issue was not raised in an earlier repetition and it is raised for the first time in the present petition, then there is no question of reciprocata at all. So the reciprocata can apply whether the adjudication of the, but if I am not reciprocata, the crux of reciprocata, let me quote the mathematics very briefly. But the crux is 6 conditions should be satisfied to constitute reciprocata. That are my lord, yes. See, omnia tu idam, idem corpus, idem quantitas, idem causa, Vedam Kosa Petendi, Vedam Kandisho Personara, Vedam Kandisho Personara. All these things are put in simple words. The cause of action should be the same. The parties should be the same. The cause of action shall be adjudicated on Paris. And when it comes to recidicate or pure question of law, there is no recidicate at all. So therefore, the doctor recidicata has no application. But in my case, that also is not applicable. And let me read one more sentence. Further, the other petitions were dismissed on the ground of alternative remedy, and also to approach the bank for OTS, since mandamus would not lie for considering OTS. And there is no discussion about the 2015 notification at all. Therefore, the plea of recidicata by the bank is rejected. And my lord, only one more sentence. I don't want to trouble your lordship further, my lord. Therefore, this, in my case, the issue has never been adjudicated. Nobody has said, yes, from the day one, I have been raising the plea of that I am entitled to the protection under the MSME Act and the notification. Nobody has ever said that the first time in 11/1/2004, a bench of Justice Palermo and Justice Abed, and their lordship was pleased to hold that this notification is not mandatory, and therefore the banks are under the obligation to constitute a committee. That judgment was reversed by the Supreme Court in Chronic. And in my case, I challenged it. I was a party, one of the petitioners in that common batch of petition.
You make all these submissions before the regular court, will grant you that liberty.
No, my lord, I may be protected, my lord.
Yes.
There is there is an interim injunction operation.
Speaking to the minister.
No, my lord.
Order dated, give us the order. Speaking
Yeah, my lord. The order, may I read the order, my lord? May I read 1 second, my lord? May I read the order?
Yes.
We have heard the learned counsel for the petitioner. The matter is pending before the NCLAT, and the stay has been continued till 21st July 2025. We are not going to NCLAT. We will say the ICICI Bank is not a party at all. There is no point in going to NCLAT. We are not going to NCLAT. Prima facie, we find that. This is the order. Prima facie, we find the apprehension of the petitioner not well founded. It is very clear the steps were taken by the solution provision shall be subject to further order 640. Now, we are here because there is no order in the NCLT. We did not pursue the matter. We are not pursuing the matter before the NCLT because NCLT, the ICICI Bank is not a party. Your lordships can record that we are not pursuing the matter before the NCLT. I will not, therefore,
counsel for the petitioner.
No, my lord, I should be protected till that, till that the matter is held. Till the matter is held by the whatever forum, I should be protected.
Submitted that this court should, this is a recipe mood for speaking to the ministers. It is submitted that the petitioner should be protected by further interim reliefs, which the petitioner is entitled to. First up, we make it clear that this court had passed an ad interim order. First up, if the petitioner.
The order doesn't have any meaning. That's a problem. That the order certainly lacks in clarity. That's the difficulty. But that is a problem. My grievance is this order is neither here or there.
Which obviously shall be considered on its own merits by the regular court.
Now the question is the order is not clear. Till that, it may make it clear that till the order is clarified, the interim protection shall continue.
The interim protection granted earlier to continue for a period of 2 weeks from now.
There is no interim protection.
My lordship, there is no interim protection.
So if you may interrupt,
It's recorded in the order 14th August.
My lordship.
Remember, it is before the regular court. Yes, we have clarified that in FI.
There is no ad interim protection, my lord.
My lordship, the honorable enclave of it, they are relying the interim protection and vacated the interim protection.
Yes.
Well,
in fact,
There is no interim protection.
No interim protection.
Manage. Can get your paper. Yes,
फोटो देखना होगा. Okay.